Okay, am I on? Okay, how many of you found old gum instead of a business card? Okay, I thought a couple of you. This is employment law on crack, is the way I call the seminar, because we're going to kind of roll through things quickly. Probably won't be any time for questions, Q&A, but we'll all hang around and we'll have questions later. And there will be a lot of questions after we go through today. But anyway, we're going to try a new format. We're going to try to roll through things quickly. I've got 25 minutes, and I'm going to talk about Oklahoma legislative changes. Government Gone Wild is a good title, actually, for the seminar. There's a lot of change going on at the federal and state levels. Interestingly, and it shouldn't come as a surprise, there's a lot of change at the federal level, which I think you find onerous as far as having to implement it and having to learn and knowing what to do, et cetera, et cetera. There is an equal amount of change going on at the state level here in Oklahoma. It would appear to me that most of it is very employer-friendly. Is anybody shocked by that? The fact that the federals are doing one and the states are doing another? No. Anyway, a lot of change. We've been fortunate, too, in that we do a lot of work with the legislature. We actually represent the state Senate in their matters. So we've had an opportunity to see what's going on from the inside and to get involved and hopefully to help craft legislation which makes your lives a little bit easier. We shall see. The first thing we're going to talk about is something that hasn't happened yet, all right? But it probably will happen, and it probably should happen. Everybody here has read the stories in the Oklahoman, the papers online, about Oklahoma's workers' compensation system. And I am willing to bet that everybody in this room has had to deal with it, at least a little bit, if not extensively, over the course of your careers. It is an adversarial system. It's workers' comp court. There are workers' comp judges. There are attorneys. There are trials. It is a different court system, but it is a court system nonetheless. Oklahoma is only one of 3 states nationally that still has an adversarial court-based system for the adjudication of workers' compensation claims. You guys know that. But even states like Oregon and California, where you would expect that there would be a very pro-employee, more liberal system, they long ago went to a different type of system because of the inefficiencies that are built into a judicial system where you have lawyers fighting back and forth. So what are we looking at? There is proposed legislation. It has passed the Senate. It came out 36-12, so 75% in favor, which is a supermajority. It is in the House. The House has its own version of the bill. The Senate version was 250 pages long. The House version is 318 pages long, which should give you some idea of the significance of the overhaul. They basically have proposed to take Title 85, where everything is codified, and put it in the trash can. And they're starting over. That's not an exaggeration. It's an entirely new, different law. Will it pass? The vote should come up in the next few days, business days, if not this week, next week. Probably it will. Is it guaranteed passage? No. And you've seen some of the commercials that have just started in the last few days opposing it. Those are commercials that are, frankly, sponsored by the claimants bar. They are. That's just the way it is. Claimants' attorneys make money off of the present system, which inflates the cost of the system. The average disability award out of the Oklahoma workers' compensation system as it is now is $33,000. Much higher than any state in the region. So anyway, that's what we've got presently. This is what they are proposing now. And one other cautionary note, it hasn't passed the House. We think that it will. But then after it passes the House, just so you learn the legislative process, it goes to a joint committee made up of senators and representatives, and they have to work out the differences and the disagreements between the 250-page bill and the 318-page bill. And they come up with a new bill, merge the two together, and only then is it passed, signed by the governor. So there's still some time, and there are a lot of things that could happen, and there are a lot of changes. But the big contours of the proposed legislation are as follows. We're going to convert to an administrative system. No more judges. We're going to have administrative law judges, but we're not going to have judges. An ALJ, or administrative law judge, has less power. It's a different animal. but we're going to get rid of, to a great extent, the attorneys. You guys are not, yeah, look at how about that. I'm not sure how to take that. The system, the entire system will be run by 3 commissioners, and the commissioners are going to be appointed by the governor ultimately. But the president of the Senate gets to give 3 nominees. Did I say 3? 3 nominees. And the Speaker of the House will give 3 nominees, and the governor has to select 1 from each of those groups, and then she gets to pick the 3rd. And I doubt that it's going to be her husband, but it could be. You never know. Anyway, so there'll be 3 commissioners ultimately appointed by the governor, and these commissioners will have extraordinary power under the law as it's proposed now. You can talk and debate at break about whether or not there's too much power, too much concentration of power in the governor, and then ultimately in the 3 commissioners. But these commissioners will have wide-ranging powers. Now, there will be a physicians advisory committee in addition to advise the commissioners on medical issues. Why? Because the commissioners don't have to be doctors. They don't have to be lawyers. I'm willing to bet that they probably are going to be ultimately, but they don't have to be. So there's a physicians advisory council that will advise the commission on medical practices, whether or not a medical treatment is a necessary thing for a particular type of injury, etc. And then over that, there will be an advisory council on workers' comp consisting of 9 members who are going to watchdog the system. But they're only advisory. They're not going to have real power. The real power is going to be right there in those 3 individuals. What can those 3 individuals do? Look at the first bullet point. The statute says they will create rules. That's like God. Okay? They will create rules. What rules? Well, whatever rules they want to do. Well, what kind of rules? Blah, blah, blah. It doesn't say. It's interesting. Incredible power. They will appoint the administrative law judges, who ultimately are going to be the individuals hearing the claims and making determinations. They then, in turn, will hear appeals from those ALJs if someone is dissatisfied with the administrative law judge's ruling. So, you got a loop here. It's pretty extraordinary. Think about it. They create the rules, they appoint the judges, and then they decide whether or not the judges are doing the right thing. Will that be better? Remains to be seen. A lot of it has to do with who ultimately is a commissioner. All right? The commissioners also will establish an alternative dispute resolution process, or ADR, which I think is always a good thing when it comes to any sort of employment-related dispute. To include, they will appoint individuals who will go on site. Wherever the injury occurred, that individual will go to that county and will have an informal mediation with the injured employee and an employer representative. No lawyers. Just to sit down and see if we can't work this out today. Right here on the spot. What's your injury? What do you think we need? How much is it going to cost? Let's sign a document. We're done with it. Summary process. It'll be very interesting. Okay, what can the ALJs do? They're going to hold hearings with the parties, the injured employee and the employer representative. I underlined if because the statute said, the proposed bill, I should say, says if requested. That means there won't necessarily be a hearing in the adjudication process. One or the other, the employee or the employer, will have to request the hearing or it won't occur. Then, and how does that work? They'll take the medical record. They'll take the medical record and look at it and make a determination of what the injury is, the extent of injury, the nature of treatment, and whether or not there's any disability and whether or not there's any sum of money to be paid. And they'll do it just from the paper, unless someone asks for a hearing. Obviously, there's going to have to be medical evidence. No formal rules of evidence in these hearings, if there is a hearing. The statute specifically says no formal rules of evidence. None of this, I object, all the lawyer stuff. None of that. Just tell me what you've got. Let me look at the documents. I'll make a decision. Also, right here, the last bullet point, we'll get to this in a second, here, challenges to arbitration agreements. And you're probably thinking, what the heck does that mean? What's an arbitration agreement doing in workers' comp? I'll show you in a sec. Okay, that's the administrative process as it's proposed from 30,000 feet. What if it sounds bad to you? It probably doesn't, frankly. But what if it does? There's another section. It's a three-part bill, three-part proposal, both in the Senate and the House. If you don't like the administrative process that I just described, opt out. You'll have a choice not to participate. What will you have to do? You can buy, or you will be allowed to buy, insurance for occupational injuries. That product exists now in the marketplace, just not in Oklahoma because of our current system. You'll be able to self-insure. You'll have to provide the same benefits as are available within the administrative system, but you can do it through a private insurance policy. And it will be adjudicated or determined. Adjudicated is not the right word. It'll be a claims process. TPA will decide, and then there will be an internal appeals process, very similar to what you guys have had to deal with when it comes to health insurance claims for employees and ERISA. Remember that? Ever been involved in that? This will be the same type of process. The statute has a lot of things that need to be worked out. It seems, as it's written now, to allow for additional criteria regarding covered injuries, medical charges, things like that. And the reason I bring that up is it seems to give employers some latitude and insurance companies some latitude in determining what will and won't be covered. That's going to have to be ironed out because I do think the intent of the law is that these insurance policies will have to provide, if not identical, almost identical benefits that would be available within the administrative system. And again, the statute says if you don't like the outcome of the insurance process, you can appeal to the commission, and the commission will determine what the appropriate award should be. ERISA is there with a question mark because I'm not sure if they can do that. I'm not sure if they can do that because ERISA is federal law. Federal law, especially ERISA, is really broad, and it basically says state law, we don't care. It doesn't matter. You're subject to federal law, and in this particular instance, the importance of that would be if you don't like the outcome of the insurance claims process, you have to go to federal court and file an ERISA claim. So that's something that will have to be addressed too. All right, what if you don't like the insurance piece of it? You have a third option, arbitration. As I said a moment ago, one of the things the ALJs will be able to do is determine whether or not an arbitration agreement is valid, is enforceable. That is because the third part of the statute, both versions have an arbitration component. It can be mandatory, and you guys have probably heard me, Nathan Watley, Mike Lauderdale, all of us lecture you guys and coach you guys and talk to you guys on what we consider to be the virtues of an arbitration program in the employment context. We can make it mandatory, we can make it a condition of employment, and we can use it to resolve employment claims, any kind of a claim, discrimination claims, you name it. We can do that currently. Not very many of you do. We can talk about that later. But they've taken that arbitration piece and they've plugged it into the workers' comp statute. And they've said what you do in the employment, say, discrimination context, you now can use that same tool for the adjudication of workers' comp claims. You have to have a private insurance policy. Back to number two, piece number two. You have to have an insurance policy to do this. And then you can impose an arbitration program on top of that, and you will have an arbitrator appointed, and the arbitrator will hear the evidence as to the occupational injury and make a determination. You don't have to have attorneys involved in the process, but you can. You can. And it's basically privatizing the determination of occupational injuries. Does that sound like it's going to work? It's an interesting idea. I think it can be done. I think all three of these things, especially the administrative piece, have great advantages over our present system. The administrative piece, it's easier to offer commentary on because it's been done in so many states. And a lot of the proposed legislation has been cut and pasted from other states that have done this, and it's been time tested, and they've worked out a lot of the wrinkles. So the administrative part of it's much, much easier to deal with. Number two, the insurance piece, and number three, the arbitration piece, are pretty unique. pretty novel. Not very many states have done that. And I'm not sure that any state has proposed something as sweeping as what the legislature is contemplating doing, where you have this sort of three-tiered system and you can pick and choose and determine what's best for you. So, pretty amazing stuff. And again, it's probably going to pass. Some of it, if it passes, will become effective as early as November 1 of this year. A lot of it will become effective January 1, and that'll be here before you know it. So there could be some huge changes. And again, in legislation that's that thick, that long, there are lots and lots of things that are going to present unforeseen consequences and will have to be worked out. There also are 1,000 different things that will affect the process. For example, we all have had these chronic problems with employees who are TTD forever. You know, what do you do? What do you do? The present legislation in the House sort of has a review process built in, where if you read it, it basically says you can't be TTD any longer than 1 year. But you can have an ALJ, and then the commissioner or a commissioner determine under proper evidence and proper circumstances that TTD can be extended. And I think the maximum extension would be up to, it's either 2 or 3 years, and I apologize, I've forgotten. So it's still a lengthy period of time, but in order to get there, the employee is going through a regular review process, not the employer. We're not reviewing it and making the determination, but the workers' comp system is making a determination of whether or not TTD needs to be terminated. And it can only be extended under certain circumstances with specific showings. A big improvement in that particular instance. So, there's a lot there. If you have an interest in this, all of these materials are available online. And if you have an interest, you need to contact your representative or your senator. I say this, and I feel like a civics teacher, but having worked with these people, they're working hard and they're trying to make things better, I think. And it's hard. And there aren't very many of them. You know, there are only 48 people in the state Senate, 101 in the House. It's not very many people. They listen to their constituents. I guarantee you that. I guarantee you that. If you want to have an impact on the legislative process in Oklahoma, you can. It's not like New York or California where you don't have any access. You can go to the Capitol, and you're going to find them in their offices more often than not. And they'll sit down and they will talk to you. So, a little civics reminder. If you're interested in this, and if you have some sort of an opinion, a strong opinion, you really can voice it. And now's the time to do it in the next couple of weeks. Well, the next couple of months, because again, there'll be a joint committee where they have to really iron it all out before they finally say this is the done deal. So anyway, don't lose sight of that. Massive changes coming, 99% chance that it will be passed. Other things, back to arbitration. The one thing, and this is typical in arbitration agreements, the employer is going to have to pay the arbitrator's fee. And we counsel our clients to do that. That's the cost factor in arbitration. You have to pay that arbitrator, who more often than not is an attorney or a retired judge when it comes to employment discrimination claims. In this context, I'm guessing that it's going to be either an attorney or a physician. Okay? Neither will be cheap. They're going to charge you, I don't know what they're going to charge. It's going to be set by the market, but probably $200 to $400 an hour. Something like that. And so, you know, you're going to have some expenses and you have to pay for them in order to have an enforceable agreement. It's probably a small price to pay. In the employment discrimination context, it's very cost effective. You pay up front, but you save in the long term. Okay, here's something else that the proposed statute does. Who likes workers' compensation retaliatory discharge claims? Mike Lauderdale. Why does Mike Lauderdale like them? Because he makes a lot of money off them. Yeah, me too. It's the worst claim to defend. You're stuck in state court. It's hard to make things happen. You may or may not have a good judge, and juries hate those claims. You fired somebody in retaliation for them having sacrificed their body for you to make money. Really? Okay? That's it. They're the worst claims in the world. They can get Punitive damages, emotional distress. They can get their attorney's fees. This is what's proposed. No more court claims. You'll never have to deal with one again. The commission will hear them. Back to my initial point. If you want to have power in Oklahoma going forward, get yourself appointed as one of these 3 commissioners. Serious. The governor's nothing. I mean, I'm dead serious. You're going to have a bigger impact on Oklahoma's economy than almost any other person. The commission will hear the claims and will decide them, and it will be like an administrative proceeding. You can have attorneys involved, and I presume that attorneys will be involved, but it will be an administrative proceeding in a conference room out at the comp court. You can get up to $100,000 in back pay, which sounds like a lot, but back pay is just the wages lost from the date of termination through the date of the commission's decision. And obviously, a lot of these people are going to be lower wage earners, so it's going to be a rare day when somebody actually is entitled to up to $100,000, okay, in the event they prevail. It's a cap. It's not going to be hit very often. No emotional distress. No more of that stuff. And that's always the wild card with the jury. You know, what are they going to do? Are they going to give them $5,000, $0? Are they going to give them, $50,000? It's hard to guess. But that's eliminated. No punitive damages. No punitive damages. The next thing, the prevailing party can get attorney's fees. Okay, that is huge. Okay, why is that? Because defendants, when we represent you and we just beat the tar out of the other side and we get a jury verdict and you are vindicated and you still have to pay us, but we're never going to get reimbursed. You're never going to get reimbursed from the other side. It's not going to happen. And it's certainly that's true in workers' comp retaliation claims. Here, the prevailing party can get attorney's fees, which means the employer can get their fees, whatever you paid us. Okay, why is that important? It's a huge disincentive. It's a huge disincentive to bring one of these claims. Because now the claimant's attorney is going to have to say, if we lose, they're going to come after you for their fees. Now, the odds of any claimant being able to pay those fees is slim and none. It's a piece of paper, so don't get all hot and bothered. It's not like finding a $20 bill under your seat. It's not that easy. You're not going to get them, but it's still going to have a chilling effect on claimants. From the defense perspective, it means you're going to weed out the frivolous claims, and that's a good thing. It's a good thing. Somebody's really going to have to look at their whole card and say, do I really believe it, and do I have evidence to support that my termination was retaliatory? Because if I don't, and I lose, I'm going to have a big old fat judgment following me around, and they'll garnish my wages, and they'll get a lien on my property, and they'll make my life generally miserable. At least theoretically, that'll be available to you. So a huge change. Next thing, workers' comp fraud. There has been a lot of talk about trying to crack down on it. Under the proposed legislation, it now becomes a felony to perpetrate workers' compensation fraud, which means you can be in prison for over a year. And the Attorney General has primary jurisdiction, and the Attorney General has said they will set up a fraud unit. I think the one presently is with the Insurance Commission. I may be wrong, but I think so, and the reason I'm not particularly familiar with it is they don't do anything, in my experience. This will be a different deal. The Attorney General is what? A lawyer, the chief lawyer for the state of Oklahoma with a team of attorneys. So they will, they say, prosecute these things. Local DAs can also prosecute them. The legislation as it's proposed now allows for the local DA to do it too. Okay, that's it for workers' compensation reform. That's not much, is it? Okay, here's something good. This is legislation that's actually passed. This is going to go into effect, I believe, November 1 of this year. How many of you have fought unemployment claims and lost, even though the employee just wasn't worth killing? A lot of us. And that's because in order to challenge and get benefits denied, you have to prove that this person engaged in misconduct. And we've told all of you, misconduct as it's defined under the law is a narrow definition, and it's a high threshold for the employer to get over. We are basically, as it is now, we have the burden of proof to show that this person engaged in misconduct, which in essence means that the employee was terminated for acting against our interest. But the way it's been interpreted and applied at the Commission is that it takes embezzlement or some really outrageous act to constitute misconduct. Just not showing up for work 40% of the time or sleeping on the job or doing whatever is not enough. This is some of the new language. Unexplained absenteeism or tardiness. If we can show a pattern, that's misconduct as a matter of law. Willful or wanton indifference or neglect of duties. Mismanagement. Actions or omissions in health and safety, that's a little bit higher. Dishonesty, wrongdoing. Look at the last one. Violation of a policy or rule adopted to ensure orderly work. Well, that's the point of all policies, isn't it? It's a much lower threshold, and it's going to make it easier for you to say, it's worth my time and effort to challenge these claims under the new definition of misconduct. It also means that you won't necessarily need to have an attorney. It's going to be an easier process, or at least it's intended to. So that's a big change. And then the last thing I've got is the next legislative session coming up. The things we're talking about right now is clarify the law on solicitation of employees. Someone leaves, sets up a competing business, and then suddenly they're calling people up, emailing them, they're on LinkedIn, they're on Facebook, they're saying, come work for me. It's unclear under the present law whether or not that's lawful. We think we can prohibit people from it, but we need to clarify the law. And then one thing, too, that's on the next session agenda is to revive non-competes. We can't do that in Oklahoma. We can't prevent somebody from competing against us once they leave. They can set up a competing business, and for the most part, it's lawful, and it can be done. We are talking about reviving that, probably just for highly comped employees. $100,000 a year is the threshold that's being discussed, but that's something that's back on the agenda. All right, I am done. I am 3, 4, 5 seconds over. I'm going to introduce Tony Puckett and Natalie Ramsey.
Good morning, everybody. I'm going to try not to pull my mic off with my hair here. We're going to talk, Tony and I are going to talk to you about a topic that many of you might have tuned out on in years past. You think, oh, we're going to talk about the National Labor Relations Act, National Labor Relations Board issues. I'm not a unionized shop, so this probably isn't going to impact me. Well, I'm here to tell you that that's changing, and more so we're finding that the National Labor Relations Board is taking on kind of an activist type role. It's not unusual. We're seeing a lot of that from different government agencies, kind of, government-wide. But they are definitely taking on a more activist role, partly because I think perhaps the unionized workforce is on the downslide, and partly because the political agenda, I think, out there in the climate has changed quite a bit. But what we used to see the Labor Board doing is expanding rights for employees and for unions. They were interpreting things. They were just kind of working off of existing law. And now what we're seeing is them backtracking off of some areas of law that have been very long, well-settled areas. And one of those things, for example, Tony's going to talk about, will include witness statements in connection with investigations. And again, this is not limited to areas where we're only talking about unionized employers. We're talking about all of you. When we're doing an investigation, sometimes with regard to harassment issues, where we've routinely assured confidences to our employees, and now we're faced to have to deal with the possibility of those particular disclosures and witness statements being disclosed. The other thing to recognize is that with the activist attitude of the board, their authority is expanding. And so again, whereas you might not have felt like the National Labor Relations Board was going to impact you in the workplace as much, or your operations, that may very well be changing. We're going to talk a little bit about ways to deal with these changes. We're going to talk about handbooks and some of the policies and procedures that we've seen the board striking down. We're going to talk about social media and how the National Labor Relations Board decisions have really begun to to crack down on an employer's social media policy, their practices, and how they're handling employees interacting in that venue and on those sites. And then the last thing we're going to talk about is maybe just a little bit of hope that some of these activist decisions that we're having to manage and deal with may very well not actually have impact, and Tony is going to hit on that for us. But the first thing we're going to talk about, the first things that I'm going to talk about with you this morning are social media. And social media has exploded, and not unlike the fact that social media is kind of an exploding area and venue for people to interact in the world, the National Labor Relations Board decisions with regard to social media issues have likewise seen a very significant increase, and we're seeing more and more cases come out such that it's hard sometimes to give advice because the change is pretty frequent. You know, for a time there was the thought that everybody needed a social media policy, and some people drafted pretty strict policies that had pretty onerous guidelines on what they wanted their employees to do and not to do. And we're finding that some of those policies are falling by the wayside. Most of the time, when these policies are challenged, what happens is you've got an employee who's disciplined in some way with regard to a post that they've put up on Facebook. And Facebook tends to be the more common location, but you certainly need to know that there's no limitation here. It's Facebook, it's Twitter, it's LinkedIn and blogs and any number of places that people interact on the internet. But generally how this comes down is there's an employee who's disciplined for something that they've posted in relationship to their employer or in relationship to the workplace. And oftentimes those posts have been found to be critical of employers, critical of the workplace or working conditions. And when that disciplinary action comes down, the employee then heads off to file an unfair labor practice charge. And again, this is an area where any one of us, any employer can be impacted. So if you've got a social media policy and it's very aggressive with regard to limiting what your employees can and can't do, recognize that this particular discussion is absolutely relevant to you. The board has taken the attitude that interactions by employees on Facebook or on social media websites are much like those conversations that they used to have around the water cooler, in the parking lot, amongst themselves. Unfortunately now, their venue and the breadth of the distribution of those conversations is far, far greater. But what the board views those conversations in many respects as concerted activity and protected under Section 7. That the employees are, if to the extent that they're talking about working conditions, they're talking about wages or benefits, any of those things, that their actions can in fact be protected. And sometimes those conversations and those statements that they post can and will be pretty inflammatory. They can be very negative. They can put supervisors in a poor light. They can speak poorly about what it's like to work for the company. And all of those things have found protection under the Labor Board's more recent decisions, particularly under Section 7. It's considered concerted activity for the mutual aid and protection of the employees. One example of a pretty recent case, there were some employees who, amongst themselves, one of the employees decided that, you know, she didn't really feel like her coworkers were pulling their weight. And she shared that particular feeling with another worker, and that worker went and then posted online, you know, Mrs. Jones feels like our workforce isn't pulling their weight. They're not doing all that they need to do. What do you think? And naturally, she was, you know, all these people are friends on Facebook because we're friends with everyone, right? I mean, I don't know about you, but the people that I'm friends with on Facebook, half of them I haven't seen probably in 20 years. But nevertheless, there's a conversation that starts, and many times, not surprisingly, these Facebook conversations are attended in essence by coworkers, because those are the people that you actually see on a day-to-day basis. And the person who was called out in the Facebook post went to her employer and said, "Hey, I feel like I'm being bullied. You guys have a bullying and anti-harassment policy, and look at this Facebook post. This person has defamed me and suggested that I have ill feelings of my fellow employees, and has now put me in a terrible position. My coworkers are furious at me because this person has suggested that I think they're all doing a lousy job." The employer reviewed that, and the employer concluded, you know what, this seems to maybe smack of bullying and harassment. And ultimately, the employees who the employee who posted the Facebook post about her coworker, and those then who chimed in and had some negative things to say in follow-up were all terminated. In that situation, the board said, sorry, this is protected activity. Even though it may smack of bullying and you may be able to try to compartmentalize it under a different policy, at the end of the day, the board found that conversation about the coworker and about the working conditions and the quality and whether or not they were pulling their weight, all of those things in the eyes of the board and eyes of this board were concluded to be concerted. And so that they were complaining about working conditions, and as a result, they were entitled to job protection. It's not just there's no question there are some comments that you're going to find on Facebook that you're going to have to take action on that deal with harassment and any number of issues. But I've got to tell you that on a go-forward basis, at least, when you've got employees interacting on Facebook, and it isn't just really bright line clear to you that this is something that you need to deal with from a disciplinary standpoint, I'm going to caution you that there are very few situations in which there will be such a bright line rule or a bright line indicator that you can deal with it from a disciplinary standpoint. You want to deal with every single situation where you're handling employee interaction on Facebook or on social media on an individualized basis. You want to really evaluate what's been said. Is it inflammatory? Does it violate other policies? If so, how? Is there concerted activity? Does it invite conversation from fellow coworkers? Are there complaints, but are they about working conditions? Are they about benefits? Are they about something specifically related to the job that the person performs or the environment that the person is working in? Recognize that those kinds of posts, although frustrating and challenging and things that you probably want to try to limit as much as you can, are not the kind of posts that you're going to be able to discipline employees for. And to the extent you have policies that have broad brush prohibitions on posting on Facebook about the employer at all, recognize that it's very likely that if challenged, the Labor Relations Board is going to strike those policies down as being too prohibitive and too onerous. Things you can do, things we do know, that there are some postings that are not going to be considered appropriate and that you can deal with. We've learned a little bit about those with regard to the board decisions that have come out. Things that are talking about workplace violence. In this day and age, that's become a very hot topic issue, so we know that we have to be aggressive about dealing with those, and to the extent there's a threat of violence, even in conjunction with what might be considered concerted activity, that issue is probably going to override any kind of protection on a concerted activity level. Again, postings about discriminatory behavior, where we're having issues with employees retaliating, things like that, we're going to have to address those. But you're going to want to be very careful about how you do it. And you're going to want to do it, as I said, on more of an individualized basis. The next thing I'm going to talk about are employee handbooks. Once again, kind of a surprise, the National Labor Relations Board has delved into the area of employee handbooks, employee policies. And I'll tell you that some of these policies that we're going to discuss are not going to be unlike the things that you've got in your own handbooks. And you're not going to read them and think that there's anything really troubling about them from a protected activity, a concerted activity standpoint. But the Labor Board has found that they are. Now, the case I'm going to tell you about is GSA Services Group. This is not a binding precedential case. This is a settlement agreement that was reached between an employer and a union and the board. But it's informative for us in terms of where we think the board may go. But I'll tell you, there were several overly broad provisions that were pointed out by this settlement agreement that the employer basically just agreed to scrap. Now, I'm not suggesting they completely scrapped them. They probably started over and carefully redrafted and implemented something else. But in connection with this particular settlement agreement, they basically agreed that these were going to go by the wayside. The first one, confidential information about company employees and customers. And that's not surprising. I mean, it's not uncommon for an employer to really want to keep information about their customers and about the company confidential. But in this situation and in this particular policy, confidential information wasn't really defined. There wasn't enough guidance, according to the board, for what should or shouldn't be included in that definition of confidential. So it could prevent employees from talking about wages or benefits issues, that concerted activity, the things that are very tantamount to the protections of Section 7 under the National Labor Relations Act. Confidentiality of employee records, and this is a big one. Lots of times employers will encourage their employees not to talk about wages or how much they make or salary increases and those kinds of things. Absolutely not okay, according to the National Labor Relations Board. Again, falls into the category of things that employees are indeed entitled to talk about. They have protection to talk about those things under the auspices of being concerted activity. They can have these conversations through mutual aid and progression of their interest as a concerted group. Confidentiality of investigations, again, and Tony's going to talk more about that, but a broad brush prohibition on the disclosure of that information, or a broad brush prohibition on disclosing the contents of witness statements and investigation details, not going to fly. And finally, the use of communication systems. This particular policy that they had some language that kind of led to believe that you couldn't use the internal employee communication system or email system to solicit, and they use the word solicit with outside entities or groups. And again, the board said, well, that could be viewed to give the impression that the union might be an outside group, and to the extent there's some effort to organize, that could be chilling of their rights under Section 7 to engage in concerted activity. So these were all provisions that were basically, like I said, they were scrapped by the employer and probably revised, drafted a new and improved version. And you say, well, what is that new and improved version going to look like? I can tell you the things that there's been a case that's come out since the settlement agreement was reached. And that case involved a workplace code of conduct, an ethics manual, where there was a challenge to policies very similar to those that we're talking about here, that this particular employer in the GCA group decided they would go without. In that instance, what we found was there were multiple examples. The terms with regard to the prohibitions and provisions that were at issue were defined, and there were probably 40 pages of examples, which is pretty over the top. The other thing that you need to know is that the code of conduct, the handbook, so to speak, these policies, were all discussed in connection with sort of an opening morning session when these people came on and they were hired. And in this instance, to the extent you are a unionized shop, union representatives were there. It's hard for them to say that what we were trying to do was close down any kind of union activity when we invited the union to the meeting, and the union was right there and they were available to answer questions. And the final thing that this particular ethics policy had was kind of a disclaimer. And it wasn't a full like wholesale at the bottom, anything here that could be violative of the law, is struck, or anything here that's contrary to the law shouldn't be considered enforced or valid. What it really was a link to a frequently asked questions section, and that link specifically said that there wasn't anything in the code of ethics that should be construed to be violative, to the extent it was construed to be violative of any kind of law or protection the employees had, that it wasn't going to be considered valid and shouldn't be enforced in that context. So those are things that, those disclaimers can be important, probably ought to include one in every handbook, and definitions and specifics in your handbooks these days are going to be really important in avoiding unfair labor practice charges and potentially having what we consider to be kind of long-standing policies from being struck down. And I'm going to hand the reins over to Tony now. He's going to talk about investigations.
Thank you, Natalie. I think I'm on. I think I can hear it. The first part I am going to talk about is employer investigations. And this second part of our session here on the Labor Board, the NLRB, deals a little more with unionized settings. But as we've seen from Natalie's discussion of the other decisions by the board, and not just decisions in court cases, but opinion or guidance memos from the General Counsel for the National Labor Relations Board, they are stretching their rules to expand them as much as possible to non-unionized settings. So I think these rules are applicable as well for you to remember in dealing with non-unionized workforces. The case I'm going to talk about is Piedmont Gardens, and it is a case involving a unionized setting. It is a case that was handed down about employee investigations, and particularly about witness statements in employee investigations. When it was handed down, there were one or two other cases in non-unionized settings that adopted a similar rule. In this case, there was a complaint of harassment. There were witness statements taken by the employer in its investigation of the harassment complaint. And when it took witness statements, the employer's representatives, people in the HR department, assured the witnesses of confidentiality in the information they provided in the investigation. There was also a second category of witness statements in the case, and that was a woman who handed in a voluntary witness statement. She heard there was an investigation, she had something to say, she turned in a statement. There was no assurance of confidentiality given to that employee for her statement. The alleged harasser was discharged. Because it was a unionized setting, the union filed a grievance over the discharge, and as part of the pre-arbitration process, The union asked for copies of these witness statements, which is a typical process. And the employer said, no, we don't have to produce the witness statements. And the employer said no based on a long-standing rule that the NLRB had had in effect for 50 years that said employers do not have to provide witness statements from an internal investigation. There was an unfair labor practice charge filed by the union to challenge that, and the labor board adopted a new rule, said we're not going to apply the old rule anymore. The new rule is that witness statements are no longer automatically confidential. We're going to apply a balancing test. When you hear balancing test, you can think litigation because there are going to be facts that have to be determined. And the balancing test will require the employer to show a legitimate and substantial confidentiality interest that outweighs the need from the union to have that information for the arbitration, and the employer can't just say no. Even if you've got a substantial and legitimate confidentiality interest, you have to offer some accommodation to the union rather than give them the actual statement. That's the new rule from the labor board. The concern for employers, of course, is that when you do an investigation, particularly of a harassment complaint, you always want to do that with confidentiality. You have concerns about what other employees may say or do to people that provide you statements. You also have an obligation under Title VII law to conduct the investigation confidentially. That's what the EOC regulations say. So there's a tension there, and the NLRB did not really address that tension. In dealing with this situation, if you have to do an investigation, which you will, and you have witnesses to interview, you must assure the employee of confidentiality if you want to have a chance to prevail on not providing the witness statement under the new rule from the labor board. In the case, the board said because two of the witnesses were assured of confidentiality, the employer did not have to provide those. The witness who did not get confidentiality, who provided the voluntary statement, the employer had to turn over that witness statement. A couple other things that you might want to do in this situation, because you have to have a specific and legitimate need for confidentiality, is to document why you want to keep the witness statements confidential. So you can show at the time you made a decision based on the facts of the complaint you were investigating, and not just making a generalized statement that everything is confidential. And that was what the board talked about in some of the other cases handed down at the same time. As far as an accommodation to an employee, to the union rather than just saying no, again, you have to offer an accommodation. You might want to suggest that you provide a summary to the union or a synopsis of some kind, perhaps a redacted statement where portions of it are blacked out to help with privacy interests of other employees. Whether the union will agree to those, I think, is really an open question. Let me turn to other changes that we have, and these are, again, more in the traditional labor sense where you have a unionized workforce, but some of them will, again, apply to non-unionized settings. The Labor Board, as an example of its aggressiveness in adopting new rules, said it will no longer permit employers to end dues checkoff at the end of a collective bargaining agreement. In almost all collective bargaining agreement, there's a provision that says the employer will deduct union dues and remit those to the union. That's how the union gets the money to pursue its interest against the employer and on behalf of employees. The long-standing rule is when you had the end of a collective bargaining agreement, even if you were negotiating another agreement, the employer could stop doing the dues deduction. That put a lot of economic pressure on the union to agree, to reach an agreement on the collective bargaining agreement. The board says now that you can't automatically do that as an employer. You have to continue deducting dues until there's a new agreement or until there's a valid impasse in bargaining. And impasse is a term of art in the labor world. It doesn't necessarily mean that we haven't agreed yet, but you have to spend extensive time exhausting all possibilities to say we can't agree. Another new rule the NLRB adopted is now they will include front pay in the settlement of an unfair labor practice charge. Often the unfair labor practice charges arise when an employee is discharged. In some of the cases Natalie mentioned, for example, that would be the case. Traditionally, the Labor Board has only permitted back pay and reinstatement as the remedies to someone discharged in violation of the National Labor Relations Act. Now they've changed the rules to say they will permit front pay to be recovered, and that'll be part of your settlement negotiations when they say you violated the act and we want to try to resolve this. Now, this rule may help you in some respects if you can talk about front pay with the NLRB, but you could propose that in lieu of reinstatement. Very often the employer would prefer not to have these employees back, and so that gives you a way to try and avoid taking them back. Then the last rule that does apply, particularly to non-unionized workplaces, is a change in the rules on union elections. To get unionized, the union has to file a petition for representation with the National Labor Relations Board. Then the board will hold an election of all the employees in the bargaining unit to say whether they want a union, yes. They don't want a union, no. Typically, that election has been held no more quickly than 38 days after the filing the petition. 38 days. There is no other place in the law where things happen this quickly. That's a month and a half. Under the new rules, which were adopted, by the way, in April of last year to update the slide, representation elections will occur in a shorter period of time, and the best estimate we have is 21 days, so nearly half that period of time. So what does that mean for an employer? Well, if you don't know your employees are thinking about unions or might want to unionize, you get a petition filed with the National Labor Relations Board. You'll get a copy of it a day or two later. You can think you have about 20 days to mount a campaign to say we'd prefer you not to unionize. That's what's led a lot of my partners and me to suggest that you really need to be conducting your union prophylactic measures, if you will, your campaign in advance, before any petition gets filed. And that means doing things like checking your policies, things Natalie talked about, reminding employees of what a good place you have to work, dealing with employee grievances and complaints promptly and as effectively as you can to keep your employees happy so they're less likely to go seeking a union. Now, the last issue, and this is the one ray of sunshine that we can provide you today when it comes to talking about the National Labor Relations Board, and it's a big ray of sunshine, even on a cloudy, rainy day like today outside. This is Noel Canning Division versus the NLRB, and this is the case that you've probably heard about, where the D.C. Circuit ruled that the decisions from the Labor Board for the last year are invalid because there were 3 recess appointments, is the term, to the National Labor Relations Board. A recess appointment, I didn't know what that was either, and I went to law school, but it's a very seldom used provision in the U.S. Constitution that says the president can make appointments to certain boards or agencies when Congress is in recess. Congress has to actually be in recess. A long time ago, that meant they would leave Washington and go home, and they wouldn't be doing anything that could affect all of us during that period of time. Now, Congress is in session, it seems, all the time, and in this particular situation, I've read the case, and I agree with the judge, Congress was still in session. There were 3 appointments made by President Obama to the Labor Board, just as presidents back to Reagan had made hundreds of recess appointments. Only here, Noel Canning challenged that to escape the ruling from the National Labor Relations Board that it had committed an unfair labor practice, and the D.C. Circuit agreed. That meant those 3 appointments were invalid. That left the board without a quorum. That calls into question all of the rulings for the past year. All of the rulings. Everything that we've talked about so far may ultimately be ruled invalid by the Supreme Court when it gets to the Supreme Court sometime next year. So that would be a big ray of sunshine for you whether you have a union or not. And that's the end of our session. I'm going to announce for you that we have a 15-minute break, and we'll start back at 9:45. If you have questions about this labor issues, Natalie and I stick around for a few minutes during the break. Thanks for your attention.